Welcome to the second in our Autumn 2014 series of 4 short webcasts, in which we take a bite-sized look at some of the key themes emerging from the courts of the last 12 months. In today's webcast, Andrea Kidman, an associate in our finance litigation team, will be reviewing the court's approach to contractual notions of discretion and commercial reasonableness.
Hello. Commercial contracts often allow one party to the contract to exercise their discretion in relation to certain of their obligations under the contract. It is commonly understood that such discretion must be exercised in a reasonable manner, and contracts often contain a provision to that effect. In today's video, I will be looking at 3 recent cases to see what is meant by the term reasonable in this context, how the courts have interpreted this in practice, and what parties can do if they want to ensure the understanding of discretion being exercised reasonably is agreed between the parties. The first case I'm going to consider is Torah Asset Funding and RBS. Dunedin, a property company, bought a portfolio of properties. It financed the purchase with a structured loan from RBS. The loan was put in place with several loan facility agreements and an intercreditor deed. I will refer to these as the finance documents. The loan was split into several levels. Initially, the lending was all provided by RBS, but later, although RBS continued to provide some of the lending, it sold parts of the loan to other lenders. RBS acted as agent, and Torah, the claimant in these proceedings, was a lender who bought part of the loan from RBS at the junior mezzanine level. Dunedin soon found itself in financial difficulties and realised that it would not be able to meet the interest payments on the junior levels of the loan. Dunedin discussed this with RBS, but RBS never mentioned it to Torah, even though RBS was acting as Torah's agent. Dunedin and RBS came up with a proposal whereby Dunedin would stop paying interest on the junior levels of the loan. The proposal required the consent of the lenders at the junior mezzanine level. In its capacity as agent, RBS contacted Torah and asked it to consent to the proposal. When Torah asked why it was being proposed, rather than admitting it was because Dunedin could no longer afford the interest payments, RBS said it was to free up cash for improving the properties in the portfolio. Torah consented, but another lender at the junior mezzanine level refused, and so the proposal couldn't proceed. As anticipated, Dunedin defaulted on the interest payments soon afterwards and entered administrative receivership. Torah was unable to recover its loan and sued RBS for breach of its duties as agent. Torah's claim went as follows. Firstly, it said RBS failed to provide it with certain documents relating to Dunedin, which it should have done, and which would have alerted it to the problems. If it had seen those documents, Torah said, it would have tried to sell its position in the market. Secondly, Torah said RBS should have informed it of its discussions with Dunedin about Dunedin not being able to meet the interest payments, because those discussions constituted an event of default under the finance documents. Finally, Torah said RBS had made a negligent misstatement when it gave a fictitious reason as to why rolling up interest on the junior levels of the loan had been proposed. The court dismissed all of Torah's claims. It construed the finance documents narrowly and said RBS, as Torah's agent, owed no duties to Torah beyond those set out in the finance documents. With respect to the alleged negligent misstatement, RBS only owed Torah a duty to take reasonable care that the information it provided was accurate. It did not owe Torah a duty to ensure the information was accurate for the wider purpose of Torah reviewing its continued involvement in the transaction as a whole. With respect to the event of default, although there had been one when Dunedin and RBS discussed restructuring the loan, the finance documents did not require RBS to inform Torah about those discussions. With respect to the documents Torah said it should have been provided with, again, there was nothing in the finance documents requiring RBS to provide them to Dunedin. The court said the finance documents gave RBS, as agent, discretion to act as it considered to be in the best interests of Torah. The court implied a duty into how RBS had to exercise that discretion, as set out in the case of Sossamer and Standard Bank. RBS had to exercise its discretion in a manner that was limited only by concepts of honesty, good faith and genuineness, and the need for the absence of arbitrariness, capriciousness, perversity, and irrationality. In deciding whether RBS had exercised its discretion honestly and in good faith, the court said it had to consider the scheme of the contract in which the discretion arose and the commercial purpose intended to be served by the contract. The court held that the way in which RBS had exercised its discretion did comply with the SOSIMA principles, and so Torah's claim failed. The next case I'm going to consider is Forster and Bank of New York Mellon. The claimant, Forster, is a Swedish pension fund. In 2004, it entered into an agreement with Bank of New York Mellon under which the bank would manage its securities lending program on a discretionary basis. The agreement contained investment guidelines for the bank to adhere to. Forster's assets are public monies, and Forster made clear to the bank from the outset that it had a low appetite for risk. In 2005, the bank added Sigma Finance to its approved list of issuers and acquired securities from Sigma for Forster's account. In 2007, the bank became aware of problems with the securities, but did not tell Forster. It wasn't until a year later that the bank contacted Forster to discuss the situation. However, it withheld information and gave the impression that all was essentially well. As a result, Forster tightened its investment criteria but continued to hold the securities. 5 months later, Sigma defaulted and receivers were appointed. Forster suffered significant losses and brought a claim against the bank. Forster said the bank had failed to comply with its duties on 3 grounds. Firstly, the bank should not have acquired the Sigma securities for its account. They were inherently unsuitable investments, given Forster's conservative risk appetite, and did not fit with the mandate Forster had given the bank, including its chief objective, as stated in the investment guidelines, of preserving principal. Secondly, the bank should have sold the securities as soon as it realised Sigma was experiencing difficulties. Finally, when it contacted Forster about the situation, the bank should have presented the position fairly and not withheld important information. The court accepted the bank's argument that it was mandated by Forster to invest on a discretionary basis, subject to the investment guidelines, and had to use reasonable skill and care in exercising its discretion in order to comply with its contractual and tortious duties. The court agreed that the bank had used reasonable skill and care in acquiring the securities. At the time they were acquired, it was reasonable to consider them appropriate. Similarly, the bank had used reasonable skill and care in not selling them immediately on realising Sigma was experiencing difficulties. The bank could not have sold them, other than at a loss, unless it concluded a ratio trade, which was not possible within the investment guidelines without express instructions from Forster. The court considered whether the bank had a duty to seek instructions and concluded that it did not. It was for the bank to decide if and when to contact Forster. However, the court said the bank had breached its duties in respect of the information it had provided Forster. Forster only kept the securities on the basis of what the bank had told it. The information provided was misleading and didn't give a fair view of the bank's concerns. Relevant facts were omitted which were necessary to give a proper picture. The bank had a duty to inform Forster that there was a serious risk of loss. The court said the bank had breached its contractual duty by not performing its obligations with the necessary care and skill required by the agreement. The bank was also liable in tort for not exercising the standard of reasonable care and skill reasonably expected of a securities lending agent. The final case I'm going to consider is the Court of Appeal's decision in Barclays Bank and Unicredit. The case related to 3 guarantees entered into between Barclays and Unicredit in 2008. Unicredit wanted to reduce its regulatory capital requirements without affecting its balance sheet, and so entered into an agreement with Barclays whereby it transferred the credit risk in some of its assets to Barclays. Barclays made quarterly payments to Unicredit in respect of any losses, and Unicredit paid quarterly premiums to Barclays. It was agreed that Unicredit could terminate the guarantees early, after a period which was expected to be around 5 years. Early termination was permitted on 4 grounds, 2 of which required Barclays' consent, such consent to be determined in a commercially reasonable manner. Less than 2 years into the life of the guarantees, Unicredit sought to terminate them early because of a regulatory change. This was one of the grounds requiring Barclays' consent. Barclays refused to consent. They accepted that early termination was contemplated by the agreement, but said the parties had clearly intended the guarantees to continue for a substantial period. Unicredit could not reasonably expect them to consent so early on, as it would deprive them of the revenue they had bargained for. They had already booked 5 years' worth of fees as a profit, and said they would agree to termination only if Unicredit paid them 5 years' worth of fees. At first instance, the judge said Barclays had withheld its consent in a commercially reasonable manner. Unicredit appealed on 3 grounds. Firstly, it said the judge was wrong to have allowed Barclays to give precedence to its own commercial interests. The court disagreed. Barclays could take account of its own interest in preference to the interests of Unicredit, because any commercial man faced with that situation would do the same. The judge said it was not easy to express an objective test for commercial reasonableness. However, what would not be commercially reasonable would be if a party withheld consent unless the other side paid a price which was way above what he could reasonably anticipate would have been a reasonable return from the contract. This was likened to the concept of Wednesbury unreasonableness, i.e., the manner of Barclays' determination would only not be commercially reasonable if it was so outrageous in its defiance of logic or accepted moral standards that no sensible person who had applied his mind to the question could have arrived at it. Secondly, Unicredit said the judge was wrong to have allowed Barclays to demand 5 years' worth of fees before consenting. The court disagreed and said the sum sought was not out of line with the reasonable return Barclays could have expected to receive had the contract run its expected course. Finally, Unicredit said the judge was wrong to have allowed Barclays to rely on pre-contractual negotiations in reaching its decision to withhold consent, because the guarantees contained an entire agreement clause. Again, the court disagreed. The entire agreement clause did not restrict Barclays from relying on pre-contractual understandings to justify the manner in which it had exercised its discretion. So, what is meant by the term reasonable when it comes to exercising discretion in a commercial contract? Well, the courts value certainty. They will give strict effect to the parties' intentions as set out in the contractual documents, and will not imply additional duties beyond what has been agreed. Parties must use reasonable skill and care in complying with their obligations under the contract, and when exercising their discretion must do so honestly and in good faith. In judging the parties' behaviour, the court will consider the contract itself and its commercial purpose. The party can give precedence to its own interests, and this won't be considered unreasonable unless it leads to a wholly disproportionate result. Parties looking for something more concrete than this could, perhaps, consider inserting a clause into their contract explaining what they mean by the term reasonable. Indeed, the judge implied this in the Unicredit decision, and so one can presumably expect the courts to uphold such provisions.